This module addresses patient confidentiality and many of the legal aspects associated with maintaining patient information. Once completed with this module, you should be able to discuss the obligation to protect patient information, discuss HIPAA, its provisions, and its applicability and impact on EMS, discuss confidentiality arising from the physician-patient relationship, describe privileged communications, and explain possible repercussions for a breach of patient confidentiality. This module addresses legalities related to patient confidentiality. In providing this information, nothing in this presentation should be construed as legal advice. Rather, the information provided is merely a broad overview of this legal subject as denoted within the National Paramedic Educational Standards. Please be aware that every state has different laws that impact EMS agencies and providers, and these laws may change over time by application of legislative action or court decisions. Federal, state, and local laws and other provisions not discussed within this presentation may also impact EMS agencies and providers. Additionally, information that was current or applicable at the time this presentation was produced may not be at the time you are watching this presentation, and new laws may have been added as well. Lastly, the legal topics and doctrines discussed within these presentations are not the totality of all laws that apply to EMS agencies and providers. There are numerous other laws and provisions that impact diverse aspects of providing EMS. If you or any other EMS provider has questions related to the laws that apply within the realm of providing EMS, additional guidance and assistance should be obtained from a licensed attorney within your area who has subject matter expertise in the specific area of law in question. To begin, common law has evolved over time to recognize the importance of certain relationships within our society over and above other societal concerns. One such recognized relationship is that between a patient and his or her physician. Our laws routinely recognize that it is of critical importance for a patient to be able to share information with his or her physician without fear of that information being used against the patient. As an example, a person seeking assistance with a substance abuse problem should be able to talk about the problem with his or her physician to better inform the physician and aid in developing an appropriate care plan for the patient. If the patient must be afraid of that full disclosure being reported to the police, that would be a problem that undermines the faith and confidence placed within that professional physician-patient relationship. While this privilege has developed over time within American common law, many states have even codified the protections within this relationship in law. In many cases, the physician's assessment findings, treatments rendered, and other information provided to the physician by the patient are protected from disclosure by the law. There are other such relationships at common law as well, such as the relationship between a member of the clergy and the penitent, an attorney and the client, and within the spousal relationship. Within the realm of EMS, it is important to recognize that a paramedic is not a physician. As such, the protections associated with the physician-patient relationship do not always apply between a paramedic and a patient. Some states have extended the protections of this relationship to paramedics. In Wisconsin, the protections of the physician-patient relationship do not extend to the EMS provider and his or her patient. Given differences in the application of patient privacy over time, in addition to other problems associated with patients being able to actually access their own personal healthcare records, Congress passed the Health Insurance Privacy and Accountability Act of 1996, which was subsequently modified in 2005 by the Patient Safety and Quality Improvement Act. This law did several things for patients to not only protect their personal health information from unauthorized disclosure, but to also ensure such data is adequately and appropriately secured while giving patients the ability to access their own personal health records. HIPAA is routinely separated into or defined by two major provisions, the HIPAA Privacy Rule and HIPAA Security Rule. The privacy rule impacts the use and disclosure of patient health information and establishes patient privacy rights while also recognizing the need to share patient data in certain situations. The security rule establishes standards for the security of patient data that is held or transferred in an electronic form. While HIPAA specifically covers healthcare providers who transmit health information in electronic form, it is hard to imagine any EMS agency that would not fall within its provisions. Even first response agencies who arguably do not transmit patient data electronically may still be covered by virtue of being a business entity that works with another HIPAA-covered entity. Beyond HIPAA, many states also have their own patient privacy laws that routinely apply to EMS providers. Often, HIPAA is cited as the reason for not sharing protected patient health information with other parties or entities. Remember, however, that HIPAA sought to strike a balance between patient privacy rights and the needs of the healthcare system to actually function. As a result, several types of disclosures are recognized as permissible by HIPAA. These privileged communications include disclosures that are necessary for the functioning of the healthcare system. For example, it would make no sense for an EMS agency to not share patient information with a receiving hospital. Such a disclosure is obviously permitted by HIPAA. Utilizing patient data to drive education and continuous quality improvement activities is permissible. When the law requires the release of information, HIPAA does not stand in the way. This would include state laws that require EMS providers to report suspected child abuse, when a subpoena is issued by a court, or even when a state's open records law requires the disclosure of certain information. Wisconsin has such a law that requires disclosure of certain EMS-run information in the event of an open records request of a governmental EMS agency. Third-party billing services must have access to certain medical information as well. Lastly, there are additional circumstances in which medical information may be released either with or without patient consent, depending upon the circumstances. In any release of patient health information, HIPAA mandates that a minimum necessary policy is followed. That means the minimum number of people necessary for processing the release of information are involved in that release, and that the minimum amount of protected patient information be released to accomplish the purpose of the release. Ultimately, HIPAA is a very complicated piece of federal legislation, and this brief introduction hardly scratches the surface of what HIPAA compliance entails. This information also does not include unique state-specific laws that further protect patient privacy rights. The short story for EMS providers is that patients have very specific privacy rights that must be protected. In this day of social media and cell phone cameras, a release of patient information is all too easy. EMS agencies and providers must be ever vigilant to ensure patient privacy is protected and releases of information do not occur. If a release of protected patient health information does occur, the HIPAA privacy rule requires agencies to proactively notify people who may have been impacted. While HIPAA does not create a private cause of action, meaning the impacted person cannot file a personal lawsuit against the agency for the breach, the Federal Department of Health and Human Services Office of Civil Rights may issue penalties of up to $1.5 million per year. Given a willful or knowing violation of HIPAA, the U.S. Department of Justice may also be involved and seek criminal penalties of up to $250,000 and 10 years in prison against the guilty party. Within states that have their own patient confidentiality laws, there may be additional penalties for a breach of patient confidentiality that may include personal civil liability for a breach, as is the case in Wisconsin. Outside of patient confidentiality laws, other defamation claims such as libel or slander could potentially be pursued against an individual EMS provider as well. In closing, patient confidentiality is very important within the healthcare realm, and every EMS provider must be familiar with all of the patient confidentiality laws that apply within his or her respective state. This presentation provided just a very brief overview of HIPAA and potential state laws related to patient privacy, and you should now be able to discuss the paramedic's obligation to protect patient information. Discuss HIPAA, its provisions, and its applicability to and impact on EMS. Discuss confidentiality arising from the physician-patient relationship, describe privileged communications, and explain possible repercussions for a breach of patient confidentiality. As with all of the legal topics discussed within these modules, EMS students and providers are encouraged to seek additional information and training through educational institutions and related resources, their EMS agencies, and qualified attorneys within their respective jurisdictions. This presentation was prepared by Waukesha County Technical College in Pewaukee, Wisconsin, and is distributed with an Attribution, Non-Commercial, Share-alike 4.0 International Creative Commons license. Copyright 2019 Waukesha County Technical College. For information on WCTC's numerous fire and EMS educational offerings, please visit us online at wctc.edu.